Hello and welcome to today's webinar. And today we're looking at an ABC of contract law for non-lawyers. So for those of you that are in practice negotiating contracts on a day-to-day basis. It's lovely to have you with me today. If you've not come across me before, my name's Jackie. I was a corporate solicitor in practice. I worked and trained at Taylor Wessing in London. I moved to the Northwest and I was at Panonis and Hammonds in the Northwest. And I specialised in mergers and acquisitions. So reviewing and looking at contracts is a very fundamental part of M&A work, which is why you've got me for today's session. Now, you can see from our list of what we're going to cover, we've got lots of things that we wanted to look at today. It is an introductory level webinar, but we're going to focus on the fundamentals. So we'll start off thinking about what a contract actually is. And then we're going to look at something that's really important for practice, which is the concept of privity and why it is relevant for you in business. We're then going to go on and think of the key elements in relation to forming a contract. And as we work through those key elements, we're going to focus on practical points all the way through. And the whole point of this is that it's only when you have all of the key elements that you actually have a binding contract. So being aware of those key elements as you are negotiating a contract is really important, because if one of those is missing, you haven't actually bound the other side in that legally binding contract that you're seeking to get. We're also going to think about pre-contractual documentation as well, as that's something you're frequently asked to do. We're going to talk about conditions precedent, comfort letters, and whether you should send out all your correspondence labelled subject to contract. Once we're happy with the contract formation, we're going to touch on the key clauses you would expect to see in a commercial contract. So we'll look at price, warranties, indemnities, exclusion limitation, term termination, and we'll look at boilerplate as well. So we're only going to introduce those key clauses, but we're going to think about why we need to negotiate things like boilerplate.